Judgment in the appeal, British Telecom plc and Telefónica.
Lord Sumption will summarise the decision of the court.
This appeal is about the charges that phone network operators levy on each other for putting calls through to their own subscribers, which emanate from another network. They are known as termination charges. The appeal is in particular concerned with termination charges for putting calls through to fixed lines with 08 numbers. 08 numbers are allocated to particular subscribers and enable that subscriber to receive calls on the basis that if the caller is calling from a fixed line, he will be charged either nothing or a reduced amount for the call. If the caller, instead of calling from a fixed line, is calling from a mobile number, however, he may not get the whole benefit of this arrangement. This is because the caller's mobile network operator may and commonly does charge him for a call which would be free from a fixed line, or charge him more from a call which would be charged at a reduced rate from a fixed line. British Telecommunications is the largest UK fixed line network operator. In 2009, it notified mobile phone network operators of a new tariff under which termination charges for calls put through to BT fixed lines with 08 numbers would be levied at rates which varied with the amount that the originating mobile network charged to the caller. The more the caller was charged by its own network for a call to an 08 number, the bigger the charge that was levied by BT for putting it through. The new tariff was not welcomed by mobile phone operators, who would either have to reduce charges to their own subscribers for originating calls to 08 numbers, or else pay more to BT for terminating them. They complained to the telecommunications regulator Ofcom. The question which arises on this appeal is whether BT's new tariff should be allowed. There has been a ding-dong battle on this subject extending over the past 5 years. Ofcom decided that the new tariff should not be allowed. An appeal from Ofcom's decision lies to the Competition Appeal Tribunal, a specialised expert tribunal with mixed lay and legal membership. The Competition Appeal Tribunal overruled Ofcom and decided that the new tariff should be allowed. On appeal to the Court of Appeal decided that it should not. The Supreme Court now unanimously decides that the Competition Appeal Tribunal was right to allow the tariff to be introduced, and that the Court of Appeal should not have interfered with its decision. The reasons are given in a judgment which I have prepared, and with which the other members of the panel, Lord Newberger, Lord Mance, Lord Toulson, and Lord Hodge, agree. The answer depends partly on the terms of the standard interconnection agreements between BT and the various mobile network operators, and partly on an elaborate European regulatory scheme known as the Common Regulatory Framework, which is contained in a number of interrelated European directives. Effect is given to these directives in the United Kingdom by the Communications Act 2003. Broadly speaking, the position is that the right to vary interconnection charges depends on the contract between the operators involved, subject to certain overriding requirements imposed by the Common Regulatory Framework. These overriding requirements include what are referred to in the directives as policy objectives and regulatory principles. Among these objectives and principles are that interconnection terms should allow the consumer to derive the maximum benefit from their subscription in terms of choice, price, and quality, and that there should be no distortion of competition in the sector. Ofcom has power under the Communications Act to decide disputes about interconnection terms, including charges, and it is required by law to decide these disputes in accordance with the policy objectives and regulatory principles. The reason why Ofcom disallowed BT's new tariff was boldly summarised that the effect on prices and quality of the service to consumers would be beneficial. So the effect of the new tariff on prices and quality of the service to consumers would be beneficial, essentially because over a period of time they would lead to a reduction of termination charges, at least part of which would probably be passed on to consumers. But Ofcom thought that the mobile network operators would be likely to try to recoup the adverse effect on their bottom line by raising charges for other services. The problem was, as they saw it, that there was no way of working out by how much the operators would seek to raise charges for other services. Ofcom therefore concluded that although there was no reason to believe that the proposed new charges would be harmful to consumer welfare, BT had failed positively to demonstrate that they would be beneficial. The Supreme Court considers, in common with the Competition Appeal Tribunal, that this was the wrong approach. Under the standard interconnection agreements that BT has with mobile network operators, BT has a contractual right to vary its charges, subject to complying with the policy objectives and regulatory principles set out in the directives, and subject to the right of the mobile network operators to complain to Ofcom if they do not comply with those objectives and directives. Ofcom has then the power to disallow the variation if the variation is inconsistent with the objectives and principles. If there is no reason to believe that the proposed tariff will be inconsistent, there is no basis for interfering with BT's contractual right to the variation. Since Ofcom has decided that there is no reason to believe that the new tariff will be harmful to consumer interests, there is no regulatory reason to interfere. It is not good enough for them to say that it may or may not be harmful to consumer interests. They do not know, which is effectively what Ofcom did say. There is an additional reason why the new tariff should be allowed, which first surfaced in the course of evidence and argument in the Competition Appeal Tribunal, and which that tribunal accepted. This is that innovative new tariffs, such as the one proposed by BT, are themselves an effective mode of competing with other operators. Therefore, the rejection of such a tariff is liable to have a damaging effect on competition in the telecommunications sector. The Supreme Court considers that this was a relevant consideration in point of law, and that there is no error of law in the way in which the Competition Appeal Tribunal arrived at its view that BT's new tariff was potentially pro-competitive. Since an appeal to the Court of Appeal and the Supreme Court is available only on points of law and not on fact, still less on expert issues of fact of this nature, and since the matter was very much within the specialized expertise of the Competition Appeal Tribunal, that tribunal's decision on that point is not open to appeal. The Supreme Court therefore allows the appeal from the Court of Appeal and restores the decision of the Competition Appeal Tribunal. What orders should be made in consequence of that decision is a matter on which we will receive written arguments in due course, but the normal consequence would be that the CAT's order would be reinstated.